Okay, Kathy, everybody gets confused by arbitration and mediation. What exactly are they and how do they differ?
Well, that's a question that really deserves a long answer, but for the purposes of today, I'm going to give you the short, down and dirty. In the California Residential Purchase Agreement, mediation between the two parties, buyer and seller, is required as a condition, even if the arbitration provision lacks the initials of both parties. In other words, it's a separate, standalone obligation. The two parties, buyer and seller, agree that in the event there should be a dispute arising out of that agreement, that they will first mediate, which is a mutually acceptable solution to a problem that isn't handed down by an arbitrator that bangs the gavel and says, you win, you lose. In a mediation, you and I, Hillary, would come to an agreement that even though we have a dispute, with the help of a mediator, we can solve our own problem and come to an agreement and accord regarding how we're going to solve it. It does cost money. Mediator services are not typically free, and both parties typically would be best represented by counsel. If you refuse to mediate as a buyer or seller, according to the residential purchase agreement that we use here in California, you lose your rights to recover attorney's fees should you arbitrate or litigate later. In other words, your failure to mediate can really cost you money even if you prevail in the subsequent litigation or arbitration. Again, these questions can be answered in detail by doing research, but the statewide buyer and seller advisory that is used in California real estate has a pretty good explanation contained within that document.
And so arbitration is something different then?
Arbitration is different. Arbitration follows mediation in the agreement, but in order for the arbitration provision to be binding on the parties, it requires the initials of buyers and sellers. If it is not initialed, then there is no agreement to arbitrate. Now, arbitration is an alternative to litigation. It's an alternative method of dispute resolution. Many feel that arbitration can be quicker than litigation. Many feel that it can be less costly than litigation. Whether that's true or not really is a case-by-case scenario. You can't really make any proclamation about whether or not that's going to always be true. An arbitrator will be selected by the parties or by whatever entity the parties might select to arrange the arbitration, and he would really function, or she would function, as a judge and would make the decision. So you would bring the dispute to the arbitrator, and the arbitrator would listen to the facts of the case, and then he would make a decision or she would make a decision. So in other words, as we talked about earlier, mediation is really a process where the two parties have a say. Arbitration, you do not. Now, there are some exceptions to arbitration, and such as small claims court. So if a dispute falls within the jurisdiction of small claims court and the parties can't come to a resolution on their own, they do not have to mediate. And even if the arbitration provision was initial, they do not have to arbitrate. They can take it immediately to small claims court. And as of this particular recording date, $7,500 is the maximum amount for small claims court in California.